Good evening, everybody. Thank you so much for joining us for the last webinar of the spring semester. Today, we will be hearing from guests Thalia González, Sydney Vermilyea, and Claire Krelitz on restorative justice practices and values in state legislation. So, welcome, everybody. My name is Hannah Cundy, and I am the graduate assistant and today for Patience Kamau, who unfortunately is unable to join us this week. I will be giving a quick orientation on how we are going to be using Zoom for the next 90 minutes. After this orientation, I will turn it over to our host, Carl Stauffer, who will more thoroughly introduce the panelists before they begin their presentation. Once their presentation comes to an end, Carl will moderate a Q&A session to field whatever questions are coming up for all of you in the audience. Now I will give you a brief orientation on Zoom. The main thing I would like to draw your attention to is when it comes to the Q&A section of the webinar, we ask that you please use the Q&A dialog box, which is a feature on Zoom that you will be able to see at the bottom of your screen. Please submit all of your questions there. If need be, please only use the chat function for any technical issues, and we will try to help you as promptly as possible. Do not use the raise hand feature because we will not be monitoring that. And now I will be turning it over to our host, Carl Stauffer.
Thank you, Hannah, and welcome. As Hannah's already welcomed you, I want to second that. Welcome to this last webinar for our spring semester. We are very excited about our panelists and the theme, but I just want to say a little bit, we appreciate everyone who's joined us in this most unusual time, and there are many words that have been used, and unusual, unchartered, unprecedented, whatever you want to say. I just want to say, these webinars have been online. We've been in this online space for a while. We've been inhabiting this online space for a while. But right now, many of us are inhabiting this space in so many parts of our lives. We're just thankful you're here. And we're looking forward to the conversation that's going to be going on here together. So my name is Carl Stauffer, as Hannah said. I'm a professor here at the Center for Justice and Peace Building in Justice Studies. And I'm particularly interested in what we're going to be talking about today because I think there's some really important conversation that needs to be happening in this sort of love-hate relationship at times in our field with legislation and all that it entails. And so it's a real pleasure to have the three panelists that we will speaking to this matter as they've put their research and study into this effort. So just by way of a few comments, you know, legislation is often understood as a really critical method or channel for change. But in other quarters where there's been critique, it's been seen in our own context as a place of compromise or even co-option. So I think some of the questions that are probably arising in all of our minds as we think about this subject matter is, when does legislation become another extension of the state's bureaucracy, you know, and the state's tendency to move in the direction of control and surveillance, and when does legislation really free up structural change and make a difference in the way we interact and network and are able to do our work? And these are two really critical questions. Before I go any further, let me just say one other thing. In 2013, we had a webinar on restorative justice as a movement with Dr. Dana Green, and her research in 2003, and then she published again in 2013, was looking at reform movements in the criminal justice system over many decades. And as she looked at those, she realized that many of the reform movements like probation and parole and others had some of the same language and the same hope and the same sort of energy as restorative justice. And yet they soon became another extension to our criminal justice system as we know it. And one of the things that she noted was that almost all of those reform movements, and she studied 3 of the major reform movements in our criminal justice system, were legislated within 10 years of their original idea becoming popular. And she wondered if restorative justice has been as flexible and as sustainable as it has because it hasn't been quickly legislated, and we're moving slowly, and the legislation is coming from the bottom up, from states, and not at a federal level like some of the other reform. So that's an interesting question to ponder as we think about going into this conversation. Let me go ahead and introduce our panelists then, and I turn it over to them. So Thalia González is a socio-legal scholar who has done a lot of work theoretically and empirically in research around the intersections of restorative justice, inequality, and public systems. Her research has been characterized as foundational in developing this connection in the field and featured in the Washington Post, the Atlantic, the Huffington Post, and many other important media outlets. Thalia holds appointments as tenured faculty at Occidental College and in the political science department, and she's also a senior scholar and adjunct professor at Georgetown University Law Center. And Thalia is a good friend and colleague, and I really appreciate her incredible voice in the field. With Thalia are Claire Krelitz, and Claire is recently graduated from Occidental College. She has degrees in political science and sociology, and she spent her senior year as a research assistant assessing Occidental's residential education in restorative justice initiative, and I'd love to hear more about some of that work. But Claire is passionate about the intersection of social justice and academia, which is really important. Currently, she works at the Los Angeles World Affairs Council, where she helps create a public educational programming about politics and international affairs. Claire, welcome. We're really glad to have you with us. And finally, Sydney Vermilyea is a senior at Occidental College, majoring in diplomacy and world affairs and minoring in Spanish language. Sydney is a lead student researcher working in collaboration with Dr. Thalia González, investigating the formalization and operationalization of restorative justice in state laws across multiple indicators and dimensions. And we're looking forward to what they have been uncovering in their research. And so I'm going to turn it over to our panelists. Thank you for being with us, and we look forward to your inputs.
Great. Thank you so much, Carl. And certainly we really appreciate both Eastern Mennonite University and the Zehr Institute hosting us for this conversation. You opened up a Pandora's box of potential questions to consider for purposes of our discussion. And I will say that our hope is that we tease out some core components in this conversation, and then more importantly, move into those questions and in that discussion. So we'll just jump to our second slide as really the introduction into what this work is. So we entered, I entered into this project about 3 years ago and have published some research already on it. And then I've had the opportunity to work with both Sydney and Claire over the last year, and then more intensely since December. And, there were a couple aims in what this project was. One, I'll say that it's definitely about applied research. There was a desire to think about those goals that you see on the right-hand side of the slide, is that, we really want to ensure that there was transparency. While social movements might look to legislation and look to policy as signs and signals of change, that's not always readily accessible. And it certainly is not always readily accessible if you don't have digital access, if you don't have the ability to navigate through some of the paid subscriptions, or even just what it is to be sort of working in that. So transparency and access was really important in thinking about this as an applied project, and also technical assistance. I have the pleasure of working with a colleague at the University of Wisconsin Law School, and we're deeply committed to making sure everything that this project produces and many of its outputs is also freely available. And that is another aspect of where and how can we provide support and technical assistance to all of the different constituencies that are thinking about how and where restorative practices are either being operationalized in the ground or codified at the state level. And then certainly as we think about that at the federal level. I think also for me, there were two dimensions in entering into this, both as someone who does empirical work and theoretical work, which was the pragmatic to say, while we've seen a slower trajectory over time relative to restorative justice in state law, these last 5 to 10 years have actually been fairly explosive, and that it's actually really difficult to keep up with how much restorative justice legislation, and by that we actually have a broader definition of statutes, court rules, and regulation as we talk about this project, is being passed on a regular basis. And so even that opportunity to know what is most current. So from a pragmatic standpoint, having that access to a current look or as current as possible, and the data set we talk about today runs through last month. And so, you know, again, we could talk to everyone in another month and it could look different in a little bit way. But then the other place was a value-based and more of a moralistic standpoint of how do we understand and consider that once it's codified at the state level or in a formal process, whether or not that's a signal of norm change or anything along those lines, where and how are we either, I think, and this was Carl's point, adhering to the values and principles that underpin what restorative justice looks like, or how you know, whatever term you're sort of using to pick up in that way, or if we're really disconnected from those, and quite frankly, then replicating structural subordination, thinking about things such as net widening, right? Which we'll talk about. Are we, you know, where and how is access and discretion really just perpetuating the same levers and mechanisms by which individuals are not getting access to restorative practices, or because they performatively are assumed to not have the skills or abilities to engage in those. And then lastly, from a legal standpoint, you know, what are the ethics, both constitutionally and in practice, that really have to be thought about if and where we're starting to see this rise? And to that end, we also pinpointed in this work the juvenile and criminal justice systems. Not to say that it hasn't disseminated and grown or transmitted across multiple public systems, but you know, it was in the 1970s that we saw the first emergence of restorative justice being codified into state law, and so we wanted to really look at the systems that had that dominance. Now, in education, there's been an incredible growth since 2008, but for us, you know, really thinking about how and where in that older sector this growth had occurred, and more importantly, sort of what were some of those key trends, those issues that were really coming up in serious and similar ways to that end. So, you know, today will really be what is the state of the states? In some ways, it's probably an overview. And so we apologize that it functions as an overview, and perhaps a little bit more of the 30,000 foot. We'll drill into some more local examples and some more specific examples. But, you know, it'll really kind of hopefully enter into some of that conversation. So I want to jump right into what our methods were and think about that a little bit more. And so that's where Sydney will come in.
Great. Thank you so much for having us. Yeah, so I'm going to jump into our methods and kind of how we went about this project. So we used Westlaw legal database to kind of complete a refined search of each state, including Washington, D.C., of their statutes, court rules, and regulations pertaining to restorative justice within the criminal and juvenile justice system. We excluded the education system from that, so we were really going through and making sure to look for legislation that only had to do with those two systems. So we obviously began with this big word, restorative justice, which is what we're looking for. We wanted to find any legislation that had this term in it and that pertained to it. But we really understood that there are so many derivatives from restorative justice, both within practices, within what that word means, within how it can materialize within communities. And so we came up with a comprehensive list of 15 search terms. And we looked through every single state, again, including DC, using these search terms to pull out legislation. We identified these 15 terms because we really wanted to look at what are the values, principles, and practices of restorative justice that we want to see being used on the ground. They were not arbitrary. They were really chosen as what we thought would yield the highest level of searches and really help us understand what the state of the states is, essentially. So terms like restorative justice, victim offender, and family group conferencing had much higher search yields, while terms such as restorative circles had much lower ones. However, it was really important to run every single term for each state to make sure that we were coming up with the most comprehensive list possible. So once we had the data for each state, we put them into a spreadsheet and began codifying them under different categories, from if they were regulation, statute, or court rule, whether they fell under the juvenile or the criminal justice system, and a various amount of other kind of categories that we identified as key trends that we'll touch on a bit later in this presentation. Simultaneously, we were creating a code book. As Professor González mentioned, we wanted to do this project to make things very transparent and accessible to people so that not only policymakers and lawyers were understanding, you know, what's going on with restorative justice in the US today, but so that anyone could really locate this data set and take a look at what was happening, how they could better implement it in their own state, in their own community. So we've been making sure to make a detailed account of how we're codifying each thing so that others can understand, to then maybe continue growing our spreadsheet. As we said, we're updating it month by month with new legislation that comes in. We did not include any proposed legislation, so all of the legislation that we found has already been enacted within states. Is the last thing I'll say on this before I turn it over to Claire.
Great, and thank you again so much for having us. So as we began sort of analyzing all of the state laws that we collected, given those search terms, we realized that we really wanted to split up how we thought about our findings into two big buckets. So the first is really the sort of 30,000-foot overview, how we wanted to sort of quantify the overall distribution of the state of the state. So we split it up into kind of these main three things that we'll be talking about today, that is trying to give that snapshot, you know, the distribution within the type of law, its use in the system, criminal versus juvenile justice, and then finally its application. So, you know, we wanted to answer questions like, with its application, at what point overall across the states is a sort of restorative justice option being offered, whether that's pre-adjudication or post-adjudication or sort of unspecified / neither. So we'll sort of provide some of that general overview. And then the second bucket is kind of been alluded to, but sort of these key trends, issues, sort of the more discrete examples and patterns, which really get at the heart of, I think, Carl, how you sort of began our introduction here, which is, I liked when you said the sort of love-hate relationship with legislation and sort of restorative practices. And so really in our sort of second deeper piece of analysis, we're gonna get at, you know, where is the conflict and tension between restorative principles and values? How is this kind of conflicting with the way it appears in state legislation? And also, you know, how are some of these pieces, how are some of these pieces of laws, you know, maybe violating legal protections or constitutional rights? So within this sort of second bucket, we're going to be talking about things like discretionary decision-making, net widening, confidentiality and admissibility, and then finally, in some cases, a pay-to-play sort of requirement for the option of restorative justice. And then moving on from here, sorry. Yeah, so then just jumping right into it, sort of what does our distribution look like? So for starters, we had 44 states that we found laws with our search terms, including 44 states plus the District of Columbia. We did find some states that it's not necessarily that they didn't have any laws at all pertaining to restorative justice, you know, they just didn't meet our specific criteria. So, you know, we excluded anything within the education system, any proposed laws or anything like that. And so within our search sort of parameters and criteria, we had 208 total laws found. And then, you know, pushing deeper into how this was distributed across the laws, we had the distribution here, and as we can see, we had an overwhelmingly sort of representation of statutes within those laws that we found. We can sort of talk more about why we might think that is, or what that means, if anybody is interested in the question section.
Great. So moving into our findings, this map is kind of a comprehensive overview of restorative justice legislation in the United States. And as you can see, there's some obvious outliers. Colorado has been a leading state with restorative justice legislation. They currently have 31 pieces of enacted legislation across both the criminal and juvenile justice. California and Texas and Vermont are up there. California has 11 right now. Vermont is at 16 and Texas is at 13. And we definitely see kind of the Pacific Northwest is getting up there, as well as states kind of all over the country. And again, these are ever-changing numbers, and we've even seen, growth within the last 6 months. So it's very interesting to keep up to date on. And so while this is a comprehensive overview, it does show kind of the stratification of these laws within the US. We're obviously seeing certain states are having an influx of legislation, while other states have zero. Like Claire mentioned, there are several states that don't have any pieces of legislation pertaining to restorative justice. In order to break this down further, we created 2 maps, one which represents restorative justice in the juvenile system and one which represents restorative justice in the criminal system by state. So clearly, again, we see inequalities based on the shading. So if you're a juvenile in Texas versus if you're going into the criminal justice system, you're going to have a difference of access to restorative justice. This kind of raises a question of, how do we even out the access that people are having to restorative justice? Obviously, if you're a policymaker or an advocate for restorative justice, you want to see kind of an equal distribution of laws across states. Yet that's clearly not what is existing, as we have, Colorado, California, Texas having a lot of access to restorative justice, and then we see a lot of these states in here are shaded very minimally, meaning that they don't have as much access. And so system was really important to look into for us, because we wanted to kind of see where exactly is this access falling. And as Claire is going to go over in just a moment, if a piece of legislation very explicitly stated that it was for juveniles, then we coded it under juvenile as well as with criminal. And some legislation did pertain to both, so we would code it for both. But language also was sometimes a little bit muddy here, as we couldn't quite tell, who exactly do they want access to go towards. But we did overwhelmingly find that criminal justice had a bit more legislation pertaining to it, and then juvenile justice was a bit more of a rare find, as you can kind of see by the shading of these 2 maps.
And I want to Sydney, in thinking about this distribution across system, is that we also have to remember that this doesn't just simply represent the time and when you might have access to restorative justice. This isn't about the when. This is just any of those 16 terms as they're then crossed against these systems. So that could mean that in any of these given states that it's an ideological statement, right? And so we'll get in further in thinking about when it shifts out of that in terms of, actual access to practice. But I think it's important to make that distinction as we think about system. Right, it could mean that the distribution in some states which look as if they yield higher, it's also because they're taking on the language of restorative justice. But then we have to ask ourselves, getting back to some of the original points, is does that actually mean that the values and principles are being lived out? Does that even, create access? Is that individuals are being viewed as the whole person, and all of those places of tension? So I think, it's important that with any of these numbers that we're really clear about. Simply noting this from a quantitative standpoint doesn't help us think fully qualitatively about what it might look like on the ground and the ways in which people are experiencing that.
Yeah, absolutely. It's so important. And to that point as well, there's a lot of legislation will just cover definitional uses of restorative justice within the state system. So that's not exactly implementing RJ, which we're going to get into a little bit later as well. But, just because Colorado has a standout 31 pieces of legislation, it does in no mean way that people who enter the system are going to have that option whatsoever. So that is an extremely important distinction. Thank you. And then Claire, I'm going to turn it over.
Yeah, and just a really quick follow-up. This just shows the actual distribution of juvenile justice versus criminal justice. And again, as Sydney alluded to, the reason that if you do the math, it adds up to more than 208 laws, as we initially said we had, is because we made the intentional decision to actually code a law that referred to, the possibility of both juveniles and the criminal justice system. We decided to code that for both. So that, we are really capturing within a law that it is, if it is referring to both, that we are marking that. And I think just the sort of, quantifying system in general, in of itself, as Professor González mentioned, doesn't always tell us that much, because the law can get really murky. It can be unspecific. It can just be a definition. It cannot be anything specific at all. But by doing this and being able to see sort of the distribution between juvenile justice versus criminal justice, we're later then able to better parse out those sort of more important qualitative metrics about access and, you know, all that kind of stuff. You know, when is restorative justice being offered to who? What does that look like, and how does that differ across system?
Great. So that then, I think, you know, that sets us up to think about this question of applicability, meaning when is the actual application of restorative practices available? Now, that doesn't mean that it's mandated, right? Although we will get into a bit of a conversation about the fact that there has been mandatory language now imported into state laws, and whether that adheres in any way to our understanding of broadly defined restorative justice or restorative principles in that way. So here, what this slide helps us understand is that when we start to now take out, because this also is representational of an even smaller subset, when we take out things like funding up a board, the composition of a committee, the intent to follow, say, balanced and restorative justice principles in the juvenile justice system. This is the time where there could be access to some form of restorative practice. And again, we're using that larger term to capture the totality of what we coded for. So that could mean, you know, a victim offender mediation or dialogue. That could mean a panel. That could mean a whole host of different ways in which it's being understood as practice or operationalized in that context. So here what you're seeing is a distinction between the pre-adjudication. So for us, that was categorized and coded as anything from pre-charge up until then you enter into the adjudicatory process, and then at that stage. There was no time where during adjudication, meaning during trial, suddenly there was an option of restorative practices broadly defined being offered to an individual or could be opted into, which makes sense, right? If you've moved down that much of a formal pathway to suddenly sort of put halt on a formal legal process and start a restorative process, I think raises a whole set of pragmatic concerns and ways in which that could happen or not. Post-adjudication then that really is, I think, what people think of as diversion, right? So what are those times when you would not ultimately move into a formal legal process, meaning an adjudication or a trial, whether that be bench trial, jury trial, et cetera, and have that as your dividing line. The post-adjudication world is what we think of as once there's been some sort of finding, then you move into restitution or some other form, or perhaps it's during time of confinement, whether that be formal confinement where you're locked in a secure facility, or when you're in a community context, or into parole and probation, which was actually some place where we've seen that there's been an increase and rise in the use of, or the potential use or application of restorative practices through parole and probation, which then opens up a whole nother set of decision makers, right? Because at the pre-trial, pre-adjudication stage, that's, you know, a whole host of individuals. At the post-adjudication stage, when you start to open it up to, you know, departments of corrections, to parole, probation, to community-based organizations, the ways in which access might then truly be available or inequity starts to really become even more lifted up is more realistic at that point. So we don't have a slide that shows this, but when you cross the system, so the criminal justice system, the juvenile justice system, thinking juveniles versus adults in the post-adjudication or pre-adjudication, not surprisingly, you see increasing dominance that juveniles have greater access to diversion. Adults, it's almost, it's more exclusively and weighted more heavily towards the post-adjudication frame. And so what does that mean? I think it affirms that the commonly held belief about juveniles being less culpable, right? They're more able to be reformed, right? This idea about accountability, rehabilitation, that is still being used in the context of restorative practices, which gets back to a question and point of tension, and that if our values from a restorative lens ask us to think about the whole person, then shouldn't the whole person be whether they're adult or a juvenile, and the arbitrary attachment of that youth or juvenile versus adult as a binary really is problematic. And so it's also really raises this question of who is worthy morally, right? But it really does align with our more traditional approach to the criminal legal system and the differentiations that we make from a formal legal standpoint about juveniles and adults. So, you know, again, it's a place where I think Carl invites this question, and for us, it invites, you know, an opportunity from a policy standpoint and an advocacy standpoint on the ground of how and where might there be a shift and change in your individual state and in an individual jurisdiction, or what might be then from a national standpoint, really a revisiting of what this looks like. And we'll pop to the next slide. So then what we really wanted to do is pivot, because part of this conversation is to also allow for discussion and questions and hear what people want to think about to the best that we can answer those, or we've thought about them, or we've been able to find an answer in a quantitative standpoint, an empirical standpoint, is to say, okay, well, if this is what we know, if we know this is the number of states plus the District of Columbia, this in the unique setting of the criminal legal system, for both adults and juveniles, there's a distribution in a particular way. Well, then what do some of these laws look like? And where are these places that we can either identify as good practices or as issues or trends or something that, quite frankly, I think there needs to be really close and careful attention from the advocacy community, and also a place where from the restorative justice community, separate from other advocacy communities that think about criminal justice reform, that think about mass incarceration, that think about structural racism, all of those remnants to slavery in this country, that is this appropriate, right? This goes back to Carl's point. Is it appropriate that we see this rise in continued use of the restorative justice language in these state systems and in these state functions? And so there's a couple of these that we'll hit on, and probably the last one, fees, is not something that anyone has thought about. And I really do thank the students that I've worked with in finding that that there is actually now a pay-to-play option in some states to even have access to restorative practices, either at the diversion, in terms of pretrial diversion, or ultimately in the end. So we'll pop to the next slide.
Great. Can anyone, there we go. So I'm going to be talking about the role of offender to start with. Role of offender is something that we codified for very early within creating this data set, because it becomes very quickly evident when you're kind of combing through this legislation that most of them have kind of this clear-cut rule of how the person who has caused harm is going to kind of interact with the system. So the first thing that I want to touch on is the language used here. And Professor González just touched on that too, how important language is within this legislation. Offender is widely used in legislation still today, and states kind of continue to subscribe to this idea, this very binary idea of victim versus offender. So I think suggesting that we kind of reconstruct that idea and shift more to you know, the idea of the person who caused harm can very much so allow us to better subscribe to the principles and practices of restorative justice by kind of rejecting the idea that we're looking at this person as the offender, and instead promoting the idea that we're kind of inviting them into the space as someone who had to do with the conflict in terms of causing harm, but it's kind of allows for a more inclusive conversation. The second thing I want to point out is on the left-hand side of the screen, there's a couple of numbers. So within the 208 pieces of legislation that we found, in 70 of them, which is over 33%, the offender was mandated to participate in restorative justice processes. So like we see at the bottom of the screen, excuse me while I move myself so I can see it, we see that here in this California code, mandatory participation. Community-based punishment essentially means that restorative justice programs such as mandatory victim restitution and mandatory victim offender reconciliation might be used as community-based punishment. However, we kind of want to, you know, pick that apart a bit, because are we really adhering to restorative justice values if we're kind of mandating that the offender put themselves into these victim restitution programs and is forced to really participate in that? Is that really going to allow the offender to reintegrate into the community, to make amends, or, you know, whatever reconciliation processes they need to go through with the victim? Is that really going to allow us to see restorative justice practiced efficiently on the ground? On the other hand, and maybe a bit more exciting, is that 61 out of 208 pieces of legislation very explicitly allowed for a voluntary participation by the offender to participate in restorative justice practices, which is around 29%. So we, in fact, do kind of see this equal-ish number of opportunities to either voluntarily participate or be mandated to. So just at the top of the box on the right, we see an example from Colorado, which essentially says that the advisement for a juvenile's advisement from the council can suggest the possibility of restorative justice practices, which is good. I think, you know, it's exciting to see that because we want them to be able to kind of choose for themselves, oh, are we going to go with this diversion process? Because it's obviously not something that should necessarily be easy or quick, but rather it's going to be, you know, something that they want to be engaged up and a part of. So that's a really important differentiation. And then in terms of back on the left with the do not specify number, again, going back to our conversation on how not every single piece of legislation even includes anything about restorative practice. It might be definitional, it might be very vague, it might be, oh, this court can potentially talk about restorative justice. It might be this court can commission that restorative justice might be in practice in the community. And so that's kind of where the do not specify number comes from, because, you know, a significant portion of this legislation doesn't have anything to say about mandatory versus voluntary. And then finally, I think just ending this slide on the purpose of restorative justice is really to create an alternative to going into an institutional practice, and to, you know, restorative justice is meant to really break the structural inequalities that have been formed in the United States in the criminal justice system. And so, you know, we're definitely concerned seeing that so many pieces of these legislation mandate that restorative justice is used. There definitely is that fear that it then will turn into something that reinforces the structural inequality rather than breaks it. And then here's just, a visual about the role of offender with the numbers on the previous slide. So as you can see, they're rather equally distributed. However, if we're really adhering to restorative justice principles and practices, ideally voluntary participation might take up a bit more of this chart instead.
And I want to make one last point before Sydney leaves, that is that, you know, again, this is looking at a 30,000-foot view as what does the law, what is the permissive nature of the law? So meaning, what does the law permit? Or what is the law requiring? And the problem too is how and where then does that translate to the work on the ground? So if you're an organization that has, you know, that is either, you know, has a formal relationship or some other way in which you're providing a set of services relative to a whole host of restorative practices, and you are and there's a mandate of engaging in those practices. One, do you feel a coercive nature that you have to do that? Two, is that actually something that from your organizational standpoint you're willing to do? Or three, from a practitioner standpoint, knowing that individuals are walking into that space being mandated by a particular court or by a particular individual to participate. And then when you back that out, you have to think about what is the coercive nature of engaging in a formal legal process. And so, you know, when someone is faced with, especially at a diversion level, if someone was faced with the choice of, well, go through a formal legal process, you know, whether, you know, for trial, for example, and take your risk there, or take this restorative justice process, right? And then I use a different tone in that way because, you know, that's often on the ground what I hear from individuals, that they're sort of being presented the softer, easier option, or the, you know, take the diversion option as opposed to, you know, going down the formal process, but yet you're being mandated to engage in what that is. I think that we all, as a practitioner standpoint, know, you know, how deeply and profoundly impactful it is to be in that space, but that it requires a willingness and ability to be in that space and to show up in that space. And so, you know, you run this risk of really feeling coerced at a whole set of points when it's in law and when it's attached to the criminal legal system, but especially when you're being mandated to practice in it. And so, you know, I just wanted to point out from a practitioner standpoint how that may or may not be resolved and the problems with that, but then also, you know, what that means as an individual as well. So, sorry, Sydney.
No, absolutely. Thank you. So then the kind of second thing that we looked into was the role of the decision maker. And what we mean by decision maker is, first of all, the state. So the state to us included the prosecutor, probation officer, court, Department of Corrections, or any other kind of department within a state entity, or kind of any other state-sponsored actors that we came across in our research. And then we kind of saw a big differentiation between the state holding power and, the any non-state any non-state actors holding power. So that would generally be community-based organizations. It was really important to look into state versus non-state actors for a couple of reasons. First of all, power and who can mandate restorative justice is obviously extremely important. If you're giving the power to the state versus the community, net widening becomes a huge factor, discretion, and just kind of who has the ability to put these practices into reality on the ground is extremely important. We also wanted to look into it because there's a big difference between kind of establishing restorative justice versus the idea of establishing a restorative justice program. And unfortunately, we often found that when the state kind of was given power, and so they would be codified as kind of the decision maker in this instance, oftentimes there was this big difference between kind of establishing restorative justice, so saying, okay, it's actually going to be happening, and this person who has, you know, been someone who's caused harm in a situation is going to be entering into a restorative justice program. That was one thing, and then there was a big difference between that and kind of this establishing the idea of a restorative justice program. So I think these two examples on the screen are useful. Firstly, from the first one, we have, you know, this idea that the Supreme Court can allocate money to their court within the state to, you know, financially depending, to establish and operate community punishment programs. So the state does hold the power in this instance, so that would have been codified under the state actor. However, there's not restorative justice going into practice in this instance. Rather, we're kind of looking to create a program. And then that differs from the example from Colorado. In this case, the court can advise the defendant of the possibility of restorative justice practices for their sentence. And so in this case, the state, again, holds the power, but instead of kind of having the power to create a commission, they're actually having the power to put restorative justice into practice. And so this next chart just kind of lays out the way that we kind of saw this play out. The majority of legislation gave the power to the state, which in many ways makes sense because we're seeing these, you know, these cases go through the court system, and we're seeing them, you know, maybe go in pretrial diversion, or maybe it's something as a post-adjudication process. And so it does make sense that the state has the power. However, you know, we're seeing net widening, I think, is a key term that we've discussed a lot in this research, in terms of, you know, there's so many different people within the state that are kind of getting to play with this power of determining who gets to use restorative justice, who has access to it. And that can be a big issue because, you know, if it's up to a court to determine which cases have restorative justice, we might see kind of a big barrier for certain people, for certain crimes, to have access to restorative practices. We might see different states making different decisions on which cases can go to restorative programs versus which cannot. Again, really diminishing the opportunity for folks to kind of not enter into the system and rather to, you know, use restorative justice. So, you know, this power play was a big finding, because it definitely makes clear that communities are not holding a ton of this power when it comes to, you know, getting to decide who uses restorative justice. It's really still remaining within the court system, which I think, unless anyone wants to add something else, brought us to our following point. Oh.
I think I was just going to say that, you know, it affirms what other empirical work has found. And the concerns, obviously, is that as we continue to heighten the control with, you know, prosecutors, with judges at the pretrial stage, or even arresting officer, is how and where does both explicit and implicit bias yield a differential set of outcomes, right? And so, you know, there was early work that was done, you know, in Arizona, looking at how Maricopa County was allowing access to ultimately restorative justice as a diversion, and not surprisingly, the distribution yielded that it was predominantly young white men. And so, why do we think about that? Well, because there are ways in which the Black bodies in particular are being constructed, and behaviors are being interpreted as, you know, ways that we should be afraid, right? We should be fearful. What is it, you know, to have, you know, adultification and other work, such as even Philip Goff work around young Black men, you know, that are influencing all of those decision makers. And there's a whole robust study, you know, within the legal academy that looks at where and how does prosecutorial discretion, you know, one, have the possibility of creating positive outcomes, but quite frankly has still fallen in the category of just continuing the same trends of structural subordination, the same trends of disproportionality. So, you know, part of this is to say, you know, this work affirms what we know then plays out on the ground, and that we still haven't seen a shift away then from who those key decision makers are, or more importantly, any level of articulation of how they get to make those decisions and then what the oversight is. So there's no state laws that provide mechanisms for oversight in terms of decisions about restorative justice. There are no laws that then allow you in a way to see any transparency about what that looks like. And then in many states on the ground, separate from what state law says, individual jurisdictions are doing it on a super ad hoc basis. So what you see in one county versus an adjacent county may look remarkably different about who ultimately gets to have access, because it's the local lead prosecutor who gets to make a set of decisions about whether it's a particular crime or, more importantly, a set of individuals. There's work that Impact Justice has done that has actually done a comparison in Oakland, and in particular Alameda County to San Francisco County, and how and where each of those two different counties as two separate jurisdictions are ultimately allowing access to or implementing the possibility of restorative practices. The same is true on the back end, right? So what is it for within the Department of Corrections that you performatively did all the things that you needed to do, including engaging in a restorative justice process, whatever that looks like, to the satisfaction of an officer within the Department of Corrections or a state official in that capacity? And if not, then what happens, right? And obviously the answer in most instances is that you are not released. This, you know, and the same is true for probation and parole, to allow different sets of individuals that really, in a lot of instances, don't actually have access to training, don't have a clear conception of what restorative justice means, to be making decisions about the ways in which someone does or doesn't get to have the freedom to live their life becomes really problematic. So, you know, I think we want to emphasize that too, that we have not seen a shift in power to decision-making to anyone else that doesn't look like the traditional state actor. So it is just that same replication of what the current criminal legal system looks like and who holds the power to make those sets of decisions, which is quite antithetical then when we think from a more broadly restorative lens.
Yeah, absolutely. Gonna move to this one.
So this is a place that that I want us to think about in a couple different ways. So there's very few states that actually offer protections for practitioners or individuals engaging in restorative processes. So we have to think about it this way. So if you choose to go down that restorative route, it means at the pretrial stage, so in a diversion context, which for juveniles, we can think about that, you are now no longer protected by the Constitution, whether that be the federal Constitution or the state constitutions, in terms of admissibility and self-incrimination, because you're not going through a formal legal process. So in that instance, the things you may or may not say, and since restorative practices and the way in which we might think about restorative practices more broadly do move through a way of how do you accept, where and how does accountability live, where and how do you talk about the experiences that both you had and the individual who was harmed had. So we get into these really clear issues of how and where do we protect individuals. So when we see a comparison here. So in the state of Alabama, in order to enter into a pretrial diversion program, which in a separate and adjoining definition includes restorative justice and victim offender mediation, you have to do a couple things. You have to waive your right to speedy trial, which is actually a fairly standard process. But the last one, the fourth one, is the most significant. You have to provide a statement admitting the participation and responsibility for the offense that was the subject of the reason that you get to go into the pretrial diversion program, and that can then be admissible in any criminal trial. So you have now set yourself up to say, I did this in order to gain access to a restorative process. but then that could be used against you, right, in any subsequent criminal trial. So you now have no protections, right? This is deeply problematic. So I invite anyone in the state of Alabama to please consider what it is to challenge this and consider the possibilities of reforming this. Now we look at a comparison, right, in the state of Nebraska, where we have in law an actual clear codification of confidentiality and privileging of information, right? We see admissions, confessions, information during a restorative program, and again, this is for juveniles, isn't going to be admitted into evidence except in the instance of rebuttal or impeachment if there was a future adjudication around that. So states have opted into it in different ways, but it's very minimal. So what's happened in the absence of this? A very loose network of memorandums of understanding, so formal agreements that have then been made between local prosecuting authorities and the practitioners and community-based organizations that are running programs, which is incredibly important, but that's a liminal space still, right? And it isn't then something where we think about, well, these really important constitutional protections that we hold near and dear about ensuring the sanctity, that we don't incriminate, that we don't find ourselves implicated in with the state in deeper and more profound ways, simply are not being exercised in restorative processes, but yet the restorative process is embedded within the state context. So at this point, there is not a way that we're hermetically sealing between the state, the formal legal process, the criminal legal system, and the restorative one. They become intermeshed in many of those instances. So there's really a risk. There's a risk both to the practitioners, because there is not a complementary, say, attorney-client privilege that exists, and it's a risk to the individuals who are engaging in this. And I think that from an ethical standpoint, lawyers and attorneys who have clients who are being offered a restorative option have to think long and hard about whether or not they want their client to do that. So there's a couple places of tension in there. One, do they feel well versed enough to have that conversation with their client? The answer may be yes, the answer may be no, right? Because there's been such a rapid rise in this. Law schools aren't teaching about restorative justice in any uniform fashion or with any deepness, right? And that's true both for judges as well. So I don't want to just single out, attorneys that are representing individuals or prosecutors who are looking to prosecute individuals. There's really just a lack of information within the legal field. But then, from the individual standpoint, this sense of coercion, especially at the pretrial diversion stage. So in the state of Alabama, do you think is it better for you to run the risk in going to trial? Maybe, maybe not. I would point to some of the empirical evidence that suggests, depending on your race and your gender, that it's probably very risky to go to trial in the state of Alabama, and many states still in this country, that you would go into and accept the pretrial diversion, including a restorative option, but that you are still now putting yourself in incredible jeopardy. So I think we have deeply constitutional questions. I think we have ethical concerns and questions about whether individuals just feel coerced to go into a process that is not protecting them and is not then restorative, not because the practice isn't restorative. I don't want to suggest that the practice that someone is engaging isn't restorative, but the structures around it and the ways in which it's being constructed, because it still lives so deeply in those state implications, are really challenging, right? And this is that place of saying, what are the tensions, and do our values about restorative justice, broadly understood, in any way get imported? And I think this is one of those places where often the answer is no. So we'll pop to our next fun one, because I'm also trying to keep track of our time.
Yeah, so this will be our last topic before we switch over to the question portion. And this is one that we found to be very significant. And that is, as we were analyzing the state laws, we realized that certain states, 7 states actually, had laws with language about a user fee or some kind of payment that was required in order to be offered the restorative justice option. So we call this the pay to play, meaning that there is an associated fee that is not, like the restitution or the reparations or anything like that. It's a separate fee that must be paid in order to be offered the restorative justice option, which opens up a whole Pandora's box of questions about access, who's more likely to be getting the restorative justice option if it requires some sort of monetary payment. And also, again, not just access, but getting back to the values and principles of what restorative practices are supposed to entail. And so across these 7 states, there were 9 different laws that we found. And within these 9 laws, there was a variety of specificity in terms of an exact amount, which we see right here. So if you want to click, yeah, great. So Montana, here we go. Participation in the restorative justice program is $150. Boom, it's very clear, it's laid out, that's how much it is. But in most of the other states, it's not this clear. So we move on to our next state, which is the state of Texas. And we see here that the resolution of criminal disputes, in which previously it's listed that the sort of restorative practices fall under that category, the fee will not exceed $350. So we have a max, but it also later goes on to say that the fees must be based on the defendant's ability to pay. So now we see a little less specificity. We still have the maximum amount of what that fee, that sort of access fee is, with a little qualification that there may be some sort of sliding scale or other considerations taken into consideration. But then moving on.
Claire, before you move on,
Yeah.
I say you should point out under B, right, when this is occurring. So this is pretrial, victim offender mediation, and that there's discretion that lies with the program director, the magistrate, or the judge in making a determination then about, one, what do payments look like? Is there a deferred basis? But I think timing is also mattering, right? So where and how then, you know, if you're being charged a particular amount, you know, does that then discourage you or disincentivize or limit your ability to even think about, well, what is the possibility of having a pretrial victim offender mediation? One, from, you know, a really profound transformative way of engaging in that work, but then also just from pretrial means that you didn't go through that formal adjudicatory process, and that, you know, going through the formal adjudicatory process leads to a whole host of other potential collateral consequences. So, you know, if we're going to suggest that diversion is something that we want and restorative practices are built into diversion, then forcing people to pay at whatever level is not something that we should see. And we've seen, and this is a very ripe discussion in other areas of law, where there's been a lot of attention paid to the ways in which fines and fees are being used to create, you know, debtors' prisons.
Yeah, totally. It's a great point. Yeah, so then our last example here in Alabama, we see that there's really no specific language whatsoever about what the user fee means, how much that means at all, which again is not only representative of kind of the larger conversation that we've been having throughout our discussion here about just the sort of, you know, vague nature of a lot of these laws, but also when we're talking about somebody's access to the restorative justice option and the actual law not specifying any sort of parameter or specifics about what that's actually going to cost. That really was something that stood out to us as being a huge red flag in terms of the discussion about fines and fees and access and all that. And
that it's on top of a payment of restitution. And it's also on top of any fines, court fees, or other fees, right? And so in this instance in Alabama, and again, I apologize for those folks that are on from Alabama and feeling a little picked on, or maybe this is getting your blood boiling and you're excited to think about challenging some of what's been codified into your state law, is that, you know, this is another layer of which someone would then be assessed a potential payment that is distinctly separate from the action that you may have engaged in that caused harm to a particular individual.
Exactly. So yeah, that I think concludes the main topics that we had to discuss today.
Yeah, we really want to open it up for questions, but, you know, Carl asked 2 big questions in the beginning about, you know, thinking about structural change, about co-optation. Certainly, I think we've alluded to some of those places as well. And again, you know, in the limited amount of time that we knew we had, we wanted to give kind of that 30,000 foot look. And now we really invite a set of questions and ways that we can talk about this research, again, from that empirical standpoint, or where we might engage in it in other ways of thinking. So I yield the floor and look forward to hearing from everyone.
Thank you very much. That was very helpful, and really brought out some really important points for us, I think, to wrestle with here in our discussion. And I'd like to encourage those who are have taken part in our time together to please formulate your questions and send them on to the Q&A. We do have a few questions that have already accumulated, and so I'm going to jump in on those. One of them is fairly straightforward. Do you have a reference for a website where the collected statutes from this research have been, you know, put together? Is there a database that people can access, and can we be linked into that, or what's the plan on that?
Sure. So we don't have a database for our research yet. I'm still working with one of my two institutions to make that happen. If you've got any pull on an institutional framework, please let me know. I will point you to work that my colleague has done that is a slight variation on this, in that she does not include court rules and regulations. So Shannon Sleva at the University of Denver has a searchable database. I don't know all of the terms that she uses, so I apologize if it, again, this is where variation in research, you will see a different yield. So for example, if you're just searching for the term restorative justice, and then that term is then being put in the different crosses and different categories, you're gonna then see one set of numbers here or somewhere else. But hers is a searchable database. It's a free database as well. The university has just been much more fabulous. Which I'm sure mines don't appreciate me saying that, but they've been able to create that. So please take a look at hers, but then you can certainly follow up with us with any questions as well.
Yeah, and I'll also point out just quickly that our personal database that we've created to kind of pull these trends out of is very easy to kind of add on to, and we've been creating it with the hope that it will eventually be able to be shareable, and kind of, you know, creating this code book so that people know exactly how we classified things in different sections. And then lastly, the laws in this PowerPoint, if it does get shared out, you can go directly view them on Westlaw in case you wanted to refer to any of those. They're hyperlinked.
Wonderful, and I would strongly encourage whatever's possible to get this information out. I think it's really helpful. Following that up, let me just put a question to the panel. Can you point towards some best practices, if you will, in quotes, gold standards that would serve as productive models to replicate in other states?
Sure. So I'll take one response of that, and then I'll invite Claire and Sydney to think about it. Certainly, I think that best practices around confidentiality and admissibility. I don't think that anyone should feel coerced to enter into a process, nor when they enter into the process. And this is maybe where Sydney will talk about the mandatory point, but once you're entering into a process, that you should not be able to then freely be in that space. And if you have to be concerned about what you say and how you say it, either because it may ultimately be, you know, what you say and the individuals that heard it, those folks may be subpoenaed and have to testify against you, really breaks down even the possibility of establishing trust and being able to then see that as a restorative process. So to me, you know, I think we have to remedy that. I think, you know, another place of a gold standard, I guess, maybe is the fact that there's not that many states that have these pay to play. So I'm not sure that I would say that that's a gold standard, but I do want to emphasize that not allowing or just, you know, that to occur in other instances. We can certainly think about gold standards relative to some of the language in which states have been clear, but I think we've also pointed out where there's some absences. But I'll yield the floor to both Sydney and Claire to think about that.
Yeah, I mean, I don't have any states off the top of my head that I can point you to and say this is the number one, but I definitely think this is a great question and is one thing to think about, you know, over the course of especially the second half of our presentation here. We were really intentionally parsing out where the faults were, and especially the ones with pay to play, confidentiality, that kind of stuff, where they're really egregious when we're thinking about the principles and values of restorative justice. But that's not to say that we didn't come across states that didn't have those. And especially, I think a big point that Professor González just kind of mentioned, there were states that were very clear about you know, what, who, what, where, when, why. I don't know if that all applies, but definitely I think when thinking about like, when is this being offered, there were states that were very clear about that. And that is helpful because then you're not just saying that you have this offering of a restorative justice alternative, like a lot of states did, just kind of sort of have some weird philosophical, you know, we have this or believe in this or think this is good, without implementing any sort of language about how that comes into fruition. But there definitely were states that were very clear about that. And I do think it's this question points to something for us to think about, which is parsing those out and thinking about how can we sort of promote those in the hopes that when other states see that, they can replicate that, or you know, others can advocate for that.
Yeah, absolutely. I think the language is a really key point here, and especially going off of what Claire said, kind of from a policymaker standpoint, it's very important to critically, you know, not just, you know, Texas has 13 pieces of legislation, which is, you know, a lot more than other states do. However, if we kind of parse those out, we see the fees are involved and there's some confidentiality with certain states. So really being critical of not looking towards numbers as being, you know, something to necessarily highlight, because there can be so many issues within those state laws. They're not being very explicit. And then secondly, I think kind of this issue of mandatory participation really detracts from the values of restorative justice and doesn't really necessarily allow participants to kind of fully immersed within the restorative practice if it's being mandated at a state level, and it also doesn't allow community-based organizations to kind of have an understanding of the desire of that person to participate. So I think that's a big issue with the language as well. Yeah.
Wonderful. Let me jump in with, there's two more questions here. In terms of confidentiality, have any states adopted confidentiality provisions? It's very specific, related to participating in restorative justice practices for student-on-student Title IX complaints.
So we're still in a murky world relative to Title IX. So Betsy DeVos obviously revoked the prior Dear Colleague letter, which put us in a place where there was the possibility of allowing for some form of restorative practice in Title IX. The universities that have used, so there's nothing at the state level. But in title, that makes sense because thinking about Title IX. But the universities that have ultimately put those practices in place, so like, for example, the University of Michigan and their work in using restorative practices in Title IX, is that they then do have confidentiality agreements. I and others have had conversations around this from a legal standpoint of sort of where and how are these truly going to be binding, and certainly our viewpoint is like any other confidentiality agreements and similar to MOUs, that they're contractual obligations, and so you have remedies associated with it. But there's nothing at the federal level, but there's also no federal guidance right now. So the guidelines have not come out again. We don't know. So it may be that ultimately the Department of Education decides that no restorative practices are not actually available. So we're in a liminal space right now around what that is. Now, there is an argument to be made that in the context of certain forms of restorative practices that you could import the protections that exist for mediators into that context. But that, again, isn't Title IX specific in that way. So I hope that helps answer that question. And I'm happy to talk about that a little bit more offline for that individual asset question.
Wonderful. We've got another question coming in here from Ingrid. Have you considered quantifying potential predictors of these different characteristics of legislation? She gives an example, such as why might we see voluntary options in some states, but mandatory options in others?
Sure. So, so as I said at the outset, this is, this work is part of a larger project, and I've looked at ways in which we understand the legalization of restorative justice, both in quantifying that and what are some of the indicators. Shannon Sleeve has also thought about that as well and published some really interesting papers thinking about it. So one way of answering that is that is that it's about politics, right? And I don't just mean that from a liberal democratic standpoint, because actually if you were to look at our map, and this is true if you look at most maps of how restorative justice has grown across the US, it isn't geographically distributed across those traditional liberal and conservative lines. In fact, a state like Texas is a good place of that, even for those that think it's going purple. I'm not quite sure that everyone would agree. And so, but the local politics come into play, and who was ultimately writing the legislation. So certainly, so this particular project isn't asking that question to analyze who like the drafters were and what were influencing them, and how and where is the use of a particular form of language, because that actually requires both a qualitative analysis for the individuals on the ground, but then also, for example, like reading the legislative history to see if there's any indicia of what that might be. But that's work that I've looked at before. That's actually work that my colleague and I at the University of Wisconsin are doing, and that we're actually doing case study analyses now across 7 target states, where from this work, we were able to say, well, let's think about these 7 states, about how it's being operationalized. Because again, what we know is written into state law, in some ways, not to be like rude and cavalier, might not mean anything. And that the presence or absence could actually not signal what the work looks like on the ground. And so being realistic about the limits of how we talk about the fact that it's in state law, certainly we're pointing to places where it's could be arguably problematic, or putting folks at risk, or a tension with values and principles and the ways we want to think about living restoratively. But just because it's there doesn't mean that it looks like that. So, I just saw the other question pop up too, Carl, but I'll let you.
Yeah, there's another one here. So I'm thinking about the voluntary participation issue we've been doing with local jurisdiction. Is there a way to create policies based on RJ principles? For example, people closest to the issue make the decision, focus on harm, repair, and healing without mandating the practice participation. So just asking any thoughts on that.
Well, so Sydney, Claire, I don't know if you want to, I'm happy to take that question as well, but I want to invite your thought.
If you want to start, I think that'd be great.
Sure. So, Kara, to your question, I mean, absolutely. The question about voluntary versus mandatory is just as it's written into the text of the legislation. And so again, how that plays out on the ground could literally be how you're describing it. And in many jurisdictions, it's actually how you're describing it is through a voluntary model, right? In that there are local decision-making boards, there are, the constituted bodies of community-based organizations. Take a place like Chicago, you have Hub, the whole Hub network, and the ways in which individuals are working together to be thinking about what that practice looks like. I think for us, when we're talking about the voluntary mandatory, is that, when the state mandates that you engage in a restorative practice and you don't want to, then is that really, is that in direct contravention to how we construct and think about a core value of restorative justice? And does it then diminish the possibility of that healing? I don't know to that second question. Maybe you don't want to do it, you're forced to do it, you go there, and it actually is a deeply and profoundly healing experience. But if we want to think about how laws might actually realize the values or be more in line with the values, and I think not having mandatory language, of mandatory participation language codified in law, but either having the voluntary language would be the gold standard. The absence of language, though, that leads to then this question of discretion. So can a prosecutor and a judge mandate you do it? Well, if the statute is silent, arguably yes. So the best practice is that it should be voluntary, and the best practice is just as you described it. And I think that's certainly what we see playing out in a lot of places, but we wanted to flag, especially from a policy side, where are some of these places that we might want to take a second look, or advocates should be really clear that when they're talking maybe more writ large about, mass incarceration, criminal justice reform, restorative justice kind of gets lumped in there a lot these days. And what does that really mean? And in your own state, what does that mean right now? And what might you really want if you want the values that you adhere to as a particular organization, or as an individual, or as a community, to look at like that when it's actually formalized into a state practice?
Yeah. And I think we also want, I think another, best practice is that legislation doesn't kind of head towards a route of, if it includes restorative justice options, that it kind of reinforces the structural inequalities that are so prominent in the United States. We really want it to kind of stay on the side of being this alternative method that really allows people to avoid becoming a part of the system, avoid becoming, potentially extremely kind of, I'm not sure what the right vocabulary here is, but we really want restorative justice to remain an option that is equal to everyone, and that kind of allows people to not become part of just such an intense system that is really promoting the structural inequality. And with that language, with that voluntary language, we think that might be a way to kind of ensure that that happens.
Wonderful. So there's space. My question and answer window is white. So please welcome any more questions from those who are with us. And in the meantime, let me just ask a question myself. I mean, I know this is probably out of the mandate of your research, but did you run across, how did you run across the role of the harmed in legislation? Was that given consideration at all? And what did that look like? Or anyone want to comment on that?
Yeah, so we did look at that, and I'll ask Sydney to kind of jump into that a little bit.
Yeah, absolutely. So right alongside our kind of delve into the role of the offender, we did look into the role of the harmed. And what we widely found, it was good in states, in a lot of states, there was a lot of mention of the victim and kind of how the victim or the person harmed was going to be involved in the restorative justice process. And again, I'm using the term victim because that is widely used in the state law. But we found that there was a lot of recognition of family members participating in the restorative justice practice if the person harmed wasn't able to or didn't want to. And so there was definitely a lot of effort from many states of kind of involving that person in the process if they so chose to. There was also some interesting moments where it would be up to the person who experienced harm to kind of say whether or not they found it appropriate for the person that they were involved in a conflict with to go through a restorative process. So it was kind of up to them. They had to enter into a discussion with the court and mandate themselves whether or not they were comfortable with that. There were similarly instances where family members, relatives, if the victim was deceased, would be able to speak up if they wanted that. There were very interesting moments as well, kind of across the 50 states, where if a person was released on parole, there was kind of a restorative process that might occur where there had to be kind of a message sent to the victim, and the victim had to then relay their kind of acceptance of that, if they were comfortable with that, if they then wanted to enter into a restorative process once the offender was kind of released from incarceration. So those were also really interesting instances where it kind of seemed almost as though the victim was going to have a bit of a say in how the release process was going to look for the offender. So yeah, there was absolutely a mention of the victim in those ways.
Wonderful.
Yeah, I mean, I think, Carl, though, that, this goes even to the Title IX question, is that for a long time, certainly victims' rights advocates were actually very concerned about the use of restorative practices, and rightfully so. But then I think that as there's been an increase in both refinement, thought, just understanding the possibilities and the realms and continuum of what that might look like, and also the deep dissatisfaction with the criminal legal system, that it actually doesn't empower victims, right? It's, stripping you of your autonomy to have the state step in and supplant you of any role in the set of determinants and decision making, and to always assume that those that have been harmed don't want to somehow figure out what that might look like in a different setting. That the legislation, I think, was trying to be attentive to that. And in fact, it was mostly older legislation that had a lot of that language in, and thinking about the protective standpoint of the person who had experienced the harm. And that's not making a judgment one way or the other, but to just think about that, I think it still did pick up that language coming out of what that work is now. It just looks different. I think that's why we see in Title IX, there's been a really strong call from a lot of victims' rights organizations, individuals, and also from students, right? And individuals who've experienced sexual harm and sexual violence, to say, this process is dissatisfying, whether it be through the state or through my university. I want something else. I want to be heard. I want to not be anonymized. And so there's an interesting interplay there in what this might look like at the state level in the criminal and the juvenile system.
Absolutely. Absolutely. I really appreciated the differentiation you made around sort of the language of offering something, or the vague sort of idea that this is a possibility, and the enabling legislation that really said this is the ways in which we want to do it. I mean, here in Virginia, we have some legislation, not much, very little, 1, 2 pieces, but the protocols around making it actually happen are very few. And so we sort of have it sitting there with, you know, very little enabling legislation following it, you know.
Well, and I think on that point, if you don't have complementary legislation that says, 1, this is available in these sets of instances, you know, this is who gets to make the decision, right? The finer points of access, but then you don't complement that with funding mechanisms to ensure that then the contracts can occur so that a community-based organization could be coming in and doing the work, then you just simply say, then it really is just an ideological statement, even though it has very pragmatic elements spelled out to it. Because if no one can do the work, it certainly isn't reasonable that it's done on a pro bono basis, right? I mean, this is the state system who, you know, is operationalizing a new form, arguably, of its particular processes, and to assume that that's going to be done without them being concretized and really ensuring that individuals are being honored for the work that they're doing, which is really, I mean, it's very powerful, it's very deep, right? It's very hard work. And so I want to emphasize that. So to the extent that when you don't have then an attachment to create the mechanism to actually ensure that it happens, then I think it's like Virginia and many states where it sits in law, but it's not happening on the ground. Or if it is, it's not happening relative to the formal legal system, which actually could be great depending on the position that you're operating from. You might not want to have anything to do with the formal legal system, because I think the last thing I would say is on the point of net widening. You know, it deeply concerns me, as much as I feel very strongly about restorative practices and restorative justice and values and the ways that we can live restoratively, that if we continue to place restorative justice into state law, it becomes the nicer, fuzzier way of continuing to do business as usual. And so to the extent, you know, let's just not actually have certain crimes be crimes anymore, right? Let's not allow the implicit and explicit bias of police officers to allow for the arrests and then ultimately the charge at the, you know, as you move into the level of moving through the system, simply because you know there's a restorative option. And I've certainly interviewed folks on the ground who say, well, you know, I think this kid, and this is thinking about a police officer in particular, I think this kid could really benefit from going through a restorative process. So I am going to go ahead and arrest, and I am going to ask that the prosecutor file a charge because we know we're going to put them in diversion. Well, no, that's just widening the net. That's bringing them into the system in a way that I think is deeply problematic. So I think even from people with best intentions that say, well, I want to try to create an avenue by which then our formal system is allowing for someone to maybe have the opportunity to heal, to go through rehabilitation, reform, whatever you want to call it, that we are really opening up the possibility of more and more individuals actually being engaged in it. So that's something that I do want to point out about net widening that isn't always part of the conversation. Yes, we want to have criminal justice reform, but is reform that we create more of these opportunities for diversion, or perhaps we just don't simply have people go into the system at any stage anymore?
All right, another question just came in here. We have maybe 2 minutes. I'm going to throw the question out there. Kerrigan, do you have enough information about when the juvenile statutes were implemented in California, Colorado, and Nebraska, and how well they align with emerging best practice and implementation integrity to have a hypothesis of when, how someone could look at their impact on public safety and youth development? Is anyone doing this work?
So I'll answer your last question first. I'm not aware of any studies that have looked at that. We have tracked in this project, but then also in prior work that I've done, we've tracked the trajectory of time. So we looked at over a temporal time frame, how and where are these different statutes, court rules and regulations being implemented, and then actually aligned those with different hypotheses about why they were being implemented. So for example, in 2008, why did we see an incredible spike in quote, restorative justice legislation? What was happening in 2008? We were in a recessionary economy. What is one of the ways in which states can limit the number of people entering into the very expensive criminal legal system, and in particular into, you know, secure confinement and into incarceration? Well, you create more opportunities for diversion. And that's exactly what happened. So, you know, that law and economics. So in some ways, I think that there have been some states, and the work of JDAI, funded by Annie E. Casey, has certainly thought about how do we take what we know about youth development, best practices in science, and approaches to what that might look like, and merge those with criminal justice policy. So I don't want to suggest that that is readily absent, but I think across the trajectory of time and in a lot of these laws, we're not necessarily seeing a temporal connection. But I would certainly be very intrigued to think about your latter question, right, and investigating that. I think in some ways, though, we're also at a bit of a disadvantage in that some of our laws are just, they're older. And so it's almost like right now we're seeing a resurgence or a surge in interest in thinking about this work coming out of, I think, a strong movement relative to mass incarceration. And so we don't quite have just yet the opportunity to perhaps test that in the same ways. But I would certainly, I would invite that, absolutely.
Wonderful. Well, thank you very much. We're going to have a last round where I'd invite any or all three of the panelists to make any final comment you might want to. Maybe a hope coming from this research, or a concern. But before we do that, I'm going to turn it over to Hannah to take us through a few announcements as part of our webinar. Hannah?
Great, thank you. Sydney, if you could stop your screen share, I'll pull up the Zehr Institute PowerPoint here. Thank you. So we do have a few announcements. This is the last webinar of the semester at the Zehr Institute. So we will be having more coming in the fall, so please check back then. Over this summer, in these coming weeks and months, if you want to access other webinars that we've done through the Zehr Institute, please feel free to visit our website, where we have a wealth of resources and webinars from several years of work in the restorative justice field, so please check that out. Also, we have our Summer Peace Building Institute has moved online this year. So that will be May 11 to June 12th. And classes are available for developmental credit or academic credit. There's a large variety of classes that are available, but a couple include Introduction to Restorative Justice and Restorative Justice Principles, Theories, and Applications, which I believe is taught by Carl and Thalia. So that should be a really incredible class. And if you're interested in registration or learning more about that process, please visit https:/emu.edu/SPI for more information. You can also just do a Google search on the Summer Peace Building Institute and get that information. This coming fall, we will be offering more STAR trainings, the Strategies for Trauma Awareness and Resilience. So STAR Level 1 in September, in January and February. So that's September 2020, January 2021, and February 2021, all at the EMU campus in Harrisonburg, Virginia, at least at this point. Although I guess all of our plans are quite up in the air. So if you're interested in those trainings, please be sure to be checking back on that. As well as STAR Level 2 will be offered in November. So please check the website for updates and more information on registration. We also offer Restorative Justice Graduate Certificate, which allows working professionals to continue working while completing their studies. And there's more information online about that. Restorative Justice in Education. There's an RJE concentration for students in the Masters in Education program. And there's also a Restorative Justice in Education certificate that's offered, a 15-hour graduate certificate for any individual that's interested in that. And you can learn more down at the website that you see at the bottom of the webpage there. Finally, the Center for Justice and Peace Building offers Masters in Conflict Transformation as well as Masters in Restorative Justice. And they are available. They allow exploration in nonviolent and restorative responses to conflict, foster reflective, value-based practice, and critical self-reflection, and are open to people from all walks of life with different backgrounds and experiences. You can learn more at emu.edu/cjp/grad. And if you're interested in more information on the Zehr Institute, please visit our website at zehr-institute.org. And now I will turn it back over to Carl and to our guests to close us off for the evening.
Sure, I'll invite Sydney and Claire to give their thoughts.
Sure. I mean, I think as you asked for a little bit of hope or something in that line, you know, I think starting at the very beginning, what Carl was saying about how sometimes legislation can sort of, you know, when thinking about restorative justice can kind of, you know, you run the risk that it's, what did you say, the extension of the state's bureaucracy, which I totally get. And I think in many ways, some of our key findings really show that how this is appearing in laws is really contradictory to what all of us who care about restorative justice are trying to do. But I do think that one thing that has sort of given me a little bit of hope and moving forward is, you know, sometimes when you look into things, like when you look into all these 208 laws, you find things that are not good, but the process and act of sort of drawing them out and talking about them, I think is in of itself something that's really necessary. So just finding, you know, the 7 states that have these fines and fees and beginning that conversation is hopefully going to halt that practice from growing, or could. So I think while some of the things we found were really, you know, like startling, just thinking about the values and practices of restorative justice, I do think drawing them out and talking about them is something that I've found to be necessary and given me some hope in the future. And thank you so much to all of you for hosting us. It's been a great past hour plus.
Thank you.
Yeah. I don't know if we just have another moment. I think doing this work has been really wonderful. And yeah, again, thanks for hosting. And I think touched on in the Q&A was this idea of theoretical versus ideological state legislation, which I think is extremely important and kind of pertains to all the points that we've touched on today. And I think, you know, returning to best practices for policymakers, really striving to be very theoretical with these pieces of legislation could not be more important. You know, even if that's explicitly saying something that maybe isn't going to be something that we want to see, like mandatory participation, still from, you know, from us as researchers, from this point of view, it's so kind of refreshing to see when laws are very explicitly stating what they mean, really, you know, kind of laying out how the person who has caused harm is going to be participating and interacting with restorative justice mechanisms on the ground. Really understanding how state actors are going to also interact with that process. And there are certain states, like, for example, Colorado just comes to the mind, that is extremely good at kind of including that language in their laws. And then there's other states that just get really wishy-washy when it comes to kind of what exactly is going on and what exactly it means. And so I think really focusing on that distinction from a policymaker standpoint is something that's going to be really important moving forward to kind of make sure that we don't, you know, move so much towards the bureaucratization of restorative justice, but rather keep its values and principles very respected, and so that we can keep seeing them being played out on the ground is going to be really important.
Thank you, Sydney.
Yeah, mine is actually has nothing to do with the research. It's really to thank Sydney and Clara and to acknowledge that, you know, this work is something that we all can and should be engaging in, right? I mean, you saw both of their bios, and it's not to actually say, oh my gosh, you know, they're not, you know, 10 years and 20 years in the field and professors. No, the point is they're not 10 and 20 years in the field and they're not professors, and that we can all be doing this work together. So to me, there's something really hopeful about the fact that as a restorative community, as a movement, what are the ways that we can be more inclusive? And so, you know, I appreciated the invitation on behalf of the Zehr Institute, but I wouldn't want to do this if it wasn't in conjunction with them. And I think I share that as the message of how and where, as we all do this work, whatever and how our work fits in to what restorative justice means to us, or within a larger restorative justice movement, how can we do that collaboratively? And how can we do that with really shedding these also very arbitrary and problematic understandings and dichotomies about who should or shouldn't have knowledge and who is the expert in the room? And so, you know, that goes to the point of our research, is that we want it to be available. We want, you know, the opportunity to say, oh, you know, something spunky is happening in your state. We're happy to share that with you. Maybe you think it's great. Maybe we think it's spunky. Who knows? But, you know, just like putting light in some of these areas that maybe just weren't quite there before, and inviting more and more and more folks. No one owns this work, and no one should feel like they own this work. So.
Wonderful. Well, thank all three of you for giving us a lot to chew on. I hope for those who participated in the webinar, it's both challenging to think about other advocacy and lobby efforts that you might be interested in or have access to, or for others, it's maybe challenging to think about what can I do to affect good legislation. I think what we're after, as we've often talked about restorative justice as a movement that we hope is bringing shifts in cultural attitudes and mindsets around punishment and you know, justice and harm. I think what we need to ask always is the legislation enabling that movement, it's guiding that movement, or is it blocking? And so what does that mean? And how do we begin to think about the wording and the process of building that legislation in line with a movement? So thank you all. And we'll close out, and thank you for everyone who attended. We'll look forward to picking this back up in the fall. And thank you all for being part of this important conversation. Have a good evening.
Thanks, everyone.
Thank you.
Thank you.